Hi everybody, it's
Hello.
3 o'clock on Friday afternoon. This is Tanya Friedman, Chief Operating Officer of Kinetics with Carl Schusterman, top immigration lawyer. And we are going to be doing our next Facebook Live session. We have been doing a series of Facebook Live sessions over the last few weeks. And we've had fantastic results. It's been so heartwarming and just amazing to get all the feedback and the questions. And we're just so grateful that we're able to provide this information and to help all of you who have questions about how nurses can come to the US. So let's get started. For those of you who have not joined our Facebook sessions before, I'm going to start off with a brief introduction of myself and of Carl, and then we'll get to the topic at hand. The topic today is adjustment of status green card. So that is what we're going to be talking about. Hopefully we will just cover that today, or if we go over time, we're going to cover it in a number of different sessions as well. Okay, so again, I'm Tanya Friedman, the Chief Operating Officer of Kinetics. We are a recruitment company. We have been going for many years. We bring international nurses to the US. I've personally been in recruitment for many, many years, and I was originally an immigrant myself many years ago, now a very proud American. And it is a passion. Hi, Perlita. I know Perlita who's joining us. Nice to see you. And I am very passionate about helping nurses make sure that they get all the right information about how to come to the US. As everybody knows, nurses are Schedule A, which means they are an occupation of short supply. Both nurses and physical therapists qualify as Schedule A. And that is where it's important to note that this immigration of international nurses in no way is taking away American positions. There is a nursing shortage in the US, which we know is going to be growing. And we look at the numbers according to the association, the American Association of College and Nursing, just reading off the numbers, the country will need to produce more than 1 million new registered nurses by 2022. So that is a lot. That's a big shortage. So really a lot of hospitals and skilled nursing facilities, surgery centers, correctionals are looking at bringing in international nurses just as another tool in their toolkit to augment or supplement what they're already doing with their recruitment of American nurses. So that's a little bit about me and why we're doing the series. So to introduce Carl, those of you who don't know who Carl is, you should all know who he is, as he's one of the top immigration lawyers. Read through his list of accomplishments, because there are many, which will tell you why he is so good at what he does. So Carl Schusterman has been practicing for over 40 years in immigration law. He served as a trial attorney for U.S. Immigration and Naturalization Service from 1976 until 1982, when he entered private practice. He's one of the very limited number of attorneys who've been designated as certified specialists in immigration and naturalization law by the California State Bar. For more than 10 years, he's been voted as one of the best lawyers in America, which is no mean feat, so very impressive. And as a super lawyer by his colleagues at the bar. Carl was featured in the February 2018 issue of Super Lawyers magazine, so very recent accomplishment. He was named as one of the top 15 corporate immigration attorneys in the US by Human Resources Executive magazine. His hard work and dedication to immigration law has earned him the highest rating in legal ability and ethics from the prestigious Martindale-Hubbell Legal Directory. He served as a member of the Immigration and Nationality Law Advisory Commission for the State Bar. He's listed on the International Who's Who of Immigration Lawyers, the Chamber U.S. Guide for Leading Business Lawyers, and he testified at a state witness on temporary visas and green cards for registered nurses before the Senate Immigration Subcommittee in Washington, D.C. So it really is an honor and a privilege to have you here, Carl. because, we know that over the last few years with retrogression, the backlog of visa bulletins, there's been a lot of misinformation about immigration and how that pertains to nurses. In our series, we've covered a lot of the different topics. And as we said today, we're going to be talking about adjustment of status green cards. So I know that there's some new memos that came out recently about adjustment of status. I know there was the one that came out on, I think it was October 1st, right? Or it was implemented October 1st.
Yeah, the October 1st, that's for about 24 years, people who were getting their green cards in the U.S. through their jobs were not required to go to interviews. It was all paperwork. And starting on October 1st, the administration said, no, everybody's going to be interviewed. So if you're a nurse or getting your green card through any occupation, expect an interview.
Okay, so that's a big change.
Huge change.
And
yes.
We're going to talk about that a little later in the session. The second big change was that, I think it was 2 weeks ago, Friday 13th.
Yes, hard to forget.
Yeah, hard to forget Friday 13th. There was a new memo that came out from the USCIS that they're no longer going to be sending out on September 11th RFEs and NOID. Notice.
Not that they didn't say they were not.
Oh,
okay. If you're applying for a benefit, and this is whether you're a nurse, whether you're getting your green card through family or through the lottery, or maybe you're not applying for a green card, just a temporary visa or TPS or whatever the benefit is. If the Immigration Service didn't think it was 100% approvable, they would send you a request to send in some additional evidence. We call that an RFE, a request for evidence.
And we're seeing a lot more of those recently.
Right. I mean, last year on the H-1Bs, which are professional workers, the number of RFEs went up about 44% over the year before.
Yeah, which is a huge jump.
But that really started backlogging them because they were just sending everybody RFEs, and they still are doing that. And then if you send in the additional information and they still didn't think it was adequate, they would send you a notice of intent to deny your application. We call it a NOID. And you would have to overcome the reasons in the notice of intent to deny if you wanted to get an approval. But now they said in many cases, and it's a long memo and it's very confusing, so we're really going to have to wait till September 11th to see how they implement that memo. But they're saying in a lot of cases, we're not going to even send an RFE or a NOID. We're just going to deny your application, which is pretty shocking. The only two words that I saw in that memo that I wanted to bring out is they said, in cases of insufficient evidence.
Okay.
Well, that could be almost anything.
Okay.
And I and through my experience with working for the Immigration Service, I can tell you that, if you get examiner A and he's the nice guy, well, he'll grant your application, or he granted your friend's application. And then if you get examiner B, who always wanted to be a prosecutor, he'll just deny it. He won't even bother with the RFE. And the other memo that's out, it has to be read in tandem with it, and it makes it really scary, the scariest thing I've seen so far. The other memo was on June 28th. And it said,
I know my stuff, right?
You
Carl?
do. You got the dates right.
Okay.
And that memo said, if we deny a benefit and you don't have an underlying status, if you're applying for adjustment of status, let's say, and you've let your H-1B or whatever your temporary visa expire, and it does take a year to get an interview, so a lot of those visas expire. We always advise our clients to keep extending it if possible.
So that they're in status.
Right.
Okay.
So the June 28th memo says if you're not in status and we deny your application, we're going to put you immediately in deportation proceedings. And
that's called, isn't it NTA?
Right. It's called a notice to appear before an immigration judge.
Wow.
And that's pretty scary.
Yeah.
So
Yeah.
on September 11th, get ready for these things to happen.
Okay. So I think it's a good idea. We can talk about these memos in a little bit more detail further in this session. But I think before we even get to that, we maybe need to just take one step back and just understand exactly what is an adjustment of status green
Sure.
card, who it applies to, what the exceptions are, what the process is. So let's maybe just start there, because it's actually quite interesting. I knew that we were going to be talking about that this week, and this week we've had a lot of instances where we've had nurses that are probably going to be looking at doing adjustment of status.
Okay.
So, we had a Canadian nurse who we placed at a hospital in California, has been there for, I think, 2 years, and just said, she's just bought a house, she wants to put down roots, and she wants to stay. We had another nurse who was on a student visa, an OPT. So,
Sure.
There have been a lot of instances. So what is an adjustment of status
Okay.
green card?
So let me go back a long time. We're going to
Okay.
go back all the way to 1952.
Wow. Okay.
Okay. I was a little kid back then. But
Yes, I wasn't born.
So the process of getting a green card in the U.S., even if you were here on a temporary visa, you always had to go back to your country, to the U.S. Embassy, and apply for your green card. That was the
Okay.
only way you could do it.
Okay.
And then in 1952, I guess, there were more airplanes or something, but they thought, well, this doesn't make a lot of sense. Why don't we have a procedure where people will pay us and they can get, this is the government, and they will get green cards without having to leave the U.S. And they called that adjustment of status.
All right.
And the form is called an I-485, okay? Although the form has gotten larger and larger over the last 40 years while I practiced immigration law.
Yes.
And now you have to submit a number of forms with it. But one of the things is you have to have entered the U.S. lawfully.
Okay.
You have to be presently lawfully in
Living-
status, although
Okay.
there are some exceptions that we'll talk about.
Okay.
And you have to be admissible to the U.S. So, if you committed fraud or a crime or something like that, you may or may not be admissible but in some cases, you have to really talk to a lawyer about this. In some cases, if the crime wasn't too recent or too serious, or if the fraud, depends on the nature of the fraud. But if it will cause extreme hardship to certain close relatives who are citizens or green card holders,
All right.
you may be able to get a waiver of the ground of inadmissibility and adjust your status. So,
So give us an example of that.
Oh, well, let me I'll back up for a minute.
Okay.
Before we talk about waivers, let's just talk about the process. So,
Kevin,
okay.
who would qualify?
Okay,
so
so
let's make sure we understand. First of all, who qualifies for adjustment of status? What kind of visas, what kind of backgrounds would
Okay.
qualify, specifically on the nursing side?
On the nursing side, so you have to have an employer who's filed an I-140 visa petition for you.
Okay.
The day they file that is called your priority date.
All right.
So it's your place in line for a green card.
Okay.
In most countries in the world, there's no backlog for nurses. They're under what we call the EB3 category, the employment-based third category for professionals. But there's a few countries in the world, notably Philippines, India, and China. And if you're born in one of those countries, there is a backlog, although, as we said last week, the Philippine nurses...
That was the good news.
Yeah, they can bring you can have a little sigh of
Yes.
relief. My wife, who's from Cebu, and I were talking about this, because the waiting time for a Philippine nurse just a couple of years ago was 6 to 8 years,
Yes.
and now it's down to 14 months.
quickly, though.
Yes, it really
It's moved
it
quickly.
really
and
has.
this month was actually a surprise
It
that
was.
it moved so quickly.
Right.
Well, I was surprised.
Yeah, it had
Yeah.
actually been backlogging slightly
Yes.
in the beginning of the year,
Yeah.
but now it jumped forward again.
Yeah, which is great.
So you have this I-140 filed and then approved by the Immigration Service. The filing, you'll get a notice of approval, and on the notice of approval, it'll show the date that it was filed. That date is your place in line.
Okay.
And you look at the visa bulletin, which is the State Department puts this out once a month. We put it up on social media and on our website, always the day it comes out.
Yeah, and on ours as well.
Okay, very good. Yeah, I mean, for us, I mean, we have 1,000 pages. That's the most popular page.
Yeah,
Everybody's
definitely.
looking at it. Yeah.
Because that's the thing that's continually moving, or hopefully moving.
Right, okay. And we also we have a monthly newsletter. There's a free subscription to that if you're interested. And Charlie Oppenheim, who I know at the State Department, he's the guy for the last 20, 30 years who's been putting out that visa bulletin. And he meets with immigration lawyers once a month, and he makes predictions based on the number of people in line, how fast those numbers are going to move in the future. So we always put his comments in the newsletter.
So do you want to share what his latest predictions are?
Well, no, my newsletter will be coming out on Monday.
Okay,
so
we'll wait for that next exciting installment. You want to keep us in suspense, Carl?
Well, I mean, we could use up 10 minutes of our half hour, so let's not do that.
All right. So everybody who's on the call and anyone who's going to be watching, please look out for that exciting update.
Okay. So when your number comes up on the visa bulletin, and the visa bulletin comes up 2 or 3 weeks before the beginning of the month that we're talking about. So if you look up on our website or on Tanya's website, you will see the August visa bulletin, even though we're still in July right now. And so you and your lawyer should get your application for a 485 adjustment of status ready now. Don't wait until August to get it ready. So the 485 is one of the things you have to file, but you also want to file for a work card, and that's called an I-765 form. You submit it along with the 485. By the way, it's all one fee, so I mean, if you didn't apply for a work card, you're wasting a lot of money because they're charging you for it.
So you may as well do that.
Right.
Okay.
You can also submit an I-131, and on the work card, it's called an advance parole, which sounds sort of criminal, right? But it's not. It's just an international travel card. So you can use that work travel card to travel in and out of the U.S. while you're waiting for an interview, which usually takes about a year to get an interview.
Okay.
And then there's a whole bunch of other forms. You do fingerprint checks, you do pictures, you do all of that. So here's how the timeline goes. You submit it, and by the way, each district office of the USCIS, the Immigration Service, they all have their own timeline. So there's not, for getting an interview.
How many are there? Do you know?
Oh, there's probably about 40.
Oh, wow.
40 plus. We link to them all on our website, so you can click whatever your local office is. I have noticed they used to give an estimate, and now they say it will be a minimum of 6 months and a maximum of 16 months.
So they give like a range.
Yeah, so I don't always find that so helpful, but...
Well, I suppose it's just an estimate.
Yes, exactly. Yeah. So you file it with, it's called the Chicago Lockbox, and they will forward it to your district office to set up an interview. But the first thing you will get in a few weeks is a receipt for the I-485 and the other forms. Then in about 3 to 4 months, they will call you in to take your fingerprints, which they'll send to the FBI in your state to make sure you don't have criminal convictions or anything like that. And then, and it's getting longer, unfortunately, about 6 months, you'll get a work card and if you qualify, the travel card as well. Okay. And then in usually around a year, you'll get that interview.
So when you say the work card, because I've heard the term the EAD card,
right.
Is that
Same
the EAD?
Thing, same thing, yeah. The EAD is Employment Authorization Document. So you can call it a work card, you can call it whatever you want, but yeah, we have a page on our website called EAD, which gets all the A through Z questions about that.
Okay, so that's the step-by-step process. So that's helpful, and I think that gives you a lot of input from a process perspective as well as from a timing perspective. But let's talk a little bit about who would qualify for an EAD. So from a nursing perspective, I mean, we have nurses who might be like, maybe there's a nurse practitioner on an H-1 visa. Maybe we have, the one nurse that I just mentioned that a Canadian nurse who's here on a TN visa. She's been here for a few years. Maybe a student visa, maybe somebody on a TPS. Can you share with us who actually qualifies
Well, if you're
in terms of from a nursing perspective?
yeah, so if you're qualified for adjustment of status, you're legally here in the United States and legally working in the U.S., then you obviously, and your priority date is current. You've waited in line and you're at the beginning. Although, as I said, unless you're from the Philippines, India, and China, there is no line.
Yes.
So you submit the I-140, your employer submits the I-140, and you submit the 485 at the same time. Okay.
Okay, so that's if you are from any other country
Right.
except India, Philippines, and China.
Right.
You're
right.
current.
Exactly.
Okay.
You're
We
at the
call it ROW, rest of the world, right?
rest of the world,
yeah.
yes. But otherwise, you have to wait and look at the visa bulletin a couple weeks before the beginning of each month. And when you see that the number on your notice of approval is ahead of whatever date that they have on the visa bulletin, you can go ahead and file for adjustment of status.
Okay.
Okay. So you could be in TPS, you can be in H-1B, you can be in OPT, you can be in H-1. All of those people would qualify.
Okay.
But there are a couple exceptions, good exceptions to this. Now, the section of law, the lawyers always refer to sections of law. It's called 245. So 245 and adjustment of status are the same thing.
Okay.
But in the years that I've been doing immigration law, they've come with two exceptions that actually help people who may not have been qualified before, but now they are. So the 245K applies to everybody who's applying for adjustment through employment base, not to family people, not to the visa lottery, but just the employment categories. And it can be, and there's 5 employment categories. As I said, nurses are in the middle, EB3, but there's EB1, EB2, EB4, and EB5 as well. And for most of those people, 240, not all, but most of those people, 245K applies. Certainly to EB3, it does apply. And it says, remember I said before, to apply for adjustment of status, you had to always be legal in the U.S. Even if you had one day where you were, you worked at a job without permission, forget it. You had to go back to the embassy in your country to get a green card. 245K was implemented by Congress a few years ago. And what 245K says is we're only, for employment-based adjustments, we're only looking at your history since your last entry in the U.S.
Okay.
So if you were here 10 years ago and you worked some job illegally, that's not going to count against you. Only if you worked since the last time you came to the U.S., and even illegally, and even if you did that, as long as you haven't done that for over 180 days, you can still adjust your status without leaving the U.S. So that's a huge benefit for a lot of people.
Okay, so this is, it's when you hear that term, it's for someone who's not a lawyer, it's
Right.
kind of your eyes kind of glaze over a little bit because it just seems like a lot of legalese, and I know it makes perfect sense to you, but for the rest of us lay people, it can be a bit confusing.
Okay, ask the question. Yes.
Okay, so give me a scenario. So say, for instance, you were a student, okay, and 10 years ago maybe your student visa expired, and then maybe you stayed over
Right.
a day or two or whatever,
Right.
the time when your student visa expired. Then you left the country and you came back into the country maybe
H-1B.
on an H-1B or another student visa or some other
Right.
kind of visa.
Right.
So what would happen in that case?
Well, you're fine because they don't care what happened before your last entry. So if you overstayed, if you worked without permission, it's not going to harm your application for adjustment of status because the time that they're going to start looking at is the last time you entered the U.S.
Oh, wow.
Yeah.
Okay.
So it pays to travel.
Yes. Okay. So that's very interesting. Wow. I didn't know that.
Okay.
So is that why, obviously, when you do your intake, with the nurses or with any other candidates, you ask so many questions
Oh,
because you're
absolutely.
trying to see if there maybe is something that may help somebody who maybe did have a problem in the
Right.
past.
Or advise them, you know,
Yes.
if we see something that happened 10 years ago, might be something very small, but under this administration, they're looking at the smallest errors.
Yes.
So we might say, well, you're on an H-1B now.
Yeah.
Why don't you, you go and take a trip to Mazatlan or something for the weekend and come back again, because then it doesn't
kind
count
of-
toward your adjustment of status.
Wow.
Yeah.
Wow,
So
wow, that's
we've
very
used it
interesting.
many, many times to help people.
Oh,
Yeah.
wow. Okay.
Okay.
Is that the only exception?
No, there's another one.
There's another one. Okay, good.
So this is an older one that started, I want to say, around 1994. And they kept renewing it until the last time they renewed it was in 2000. It's called 245I.
All right.
And we-
Another legalese.
Yeah. And we have a video and a page on our website about 245K and 245I. So 245I, a little more complicated than this, but basically, if somebody applied for you or your parents before you turned 21 and got, assuming you were not married at that time, so you were, if they filed a petition, whether it's an employer or a relative filed a petition for one of your parents or yourself on or before April 30th, 2001, then you're probably, there's a couple exceptions, but you're probably qualified to be able to adjust status in the United States as long as the petition that was filed for them, they call it approvable when filed.
So what does that mean?
Well, if your uncle, let's say your uncle applied for or your mother's uncle who applied for her, and it was his niece, okay? Well, under the U.S. immigration law, an uncle can apply for a niece. A parent can apply for a kid.
Under 21, right?
Or
they're
even
21
even
or-
over 21.
Oh, they can?
Oh,
Oh,
yeah,
okay,
yeah,
okay.
yeah. If they're a citizen, or even if they're a permanent resident. But there's certain, a grandparent cannot apply for a grandkid. An uncle can't apply for a niece. So if they did that and that happened before April 30th, 2001, well, that wasn't approvable when filed, because there is no category like that, so you don't get credit. But if there really was a category and the thing at least could have gotten approved when it was filed, could be a company applied for you, and then while it was pending, the company went bankrupt or something. So it never actually got approved, but when they filed it, it was approvable.
It was a
when
real
filed.
case and
Yeah.
a real situation.
So in those situations, again, with a few exceptions, you are locked into being able to adjust your status. So even if you've been out of status for the last 10 years, but you're in the U.S., and now an employer applies for you as a nurse or whatever, you can use 245I to adjust your status in the U.S. Or if somebody, let's say, snuck across the border from Mexico or Canada or something like that, didn't have a legal entry, 245I overcomes that too. So it overcomes illegal entry,
Yes.
it overcomes unlawful presence in the U.S., it overcomes working without authorization in the U.S. Now, they haven't renewed it since, 2000, so there are fewer and fewer people who qualify for this. But I'll tell you, every couple of months, I get another
case
245I case, and some of the people don't even know they're covered by it. What we do is we use something called the Freedom of Information Act to get their file, or maybe their parents' file from immigration. We find the approval, or we find the petition that was filed for them, and we say, oh my God, you were 18 years old when your uncle applied for your dad, and your dad never came to the U.S., but because you were unmarried and under 21 when he applied, and it was on or before April 30th, 2001, you can adjust
your
status. Yeah,
Wow.
which is
That
huge.
is crazy, because this is something, we hear a lot of I think for a non-lawyer, I know a lot about immigration, especially obviously pertaining to nurses, because we've been doing it for a long time. But these are things that, are not very well known at all.
Right. And I, especially in this time of Trump, and I know we're at 3:29, so we got about a minute before we say goodbye. But here's what I worry about a little, and I'm not trying to knock any attorneys, but when you're going around and choosing an attorney and so on, you have to be sure that the person has enough experience that they're going to understand these things. And I think, gosh, if I came out of law school 2 years ago, would I really understand all the ins and outs, and that you might be qualified? And I see on a day-to-day basis that sometimes the lawyer the lawyer happens to speak a particular language, and all the people are going to him because they can speak that language, but they don't have that much experience in immigration because maybe they're doing bankruptcy and divorces and all of that, and because they speak another language, they figure, oh well, I can get a lot more cases because I speak this language. That's probably, you should probably look for somebody who's been around a while, who knows these things like 245I, because there's a lot of, I've just done the basics.
There's a lot of nuances.
Yes, it's very complex. When they, I'll just tell you one thing, and then I guess we'll sign off. But when this was in, I can even remember the date. It was December 15th, 2000. It was right at the end of the Clinton presidency. The Democrats had a bill called the LIFA Act. The Republicans had the Life Act, LIFA and Life. The Democrats
had confusing as it is.
Yeah, totally confusing.
Yes.
And even though Clinton was a Democrat, the Congress was controlled by Republicans at that time. So they had the votes to pass the immigration bill, and the Democrats didn't. So I was, of course, sitting there writing stuff for my webpage so everybody would know what was in the Life Act. And the Life Act didn't have any extension of 245I. It had run out already. The LIFA Act, which didn't get passed, did have an extension. And I'm sitting there on the computer, and I'm talking to my wife, and she had just that day retired from the federal government. We met when she was an immigrant from the Philippines, as I said, and we met when we both worked for the Philippines, for the Immigration Service in the 70s. And then I persuaded her to go to a different agency, but she totally gets all the nuances of immigration. And she was retiring, and we were getting ready to plan a vacation. And I'm reading the Life Act, and all of a sudden I noticed that they had amended the original Life Act to include a short extension of 245I, only from whenever the president signed it, which I think was about 6 days later on December 21st, to April the 30th. Just a very brief extension. But one of the things that they reached as a compromise, because the Republicans really didn't like 245I, is it would only apply to people who are in the United States on the extension, not people who had already qualified. So people who had a relative or an employer apply for them between December 21st and April 30th, December 21st, 2000, April 30th, 2001, have to prove that they were living in the U.S. the day that Clinton signed the act.
Wow.
Yeah. People who qualified from 94 to 2000 don't have to even be in the U.S.
Wow.
So those are all the little things. And I think, oh my God, if I didn't remember that conversation with my wife and all of this, would I be able to keep that in my head?
Yes. Yeah, absolutely. Well, that's so interesting, Carl.
Yeah.
I think, the thing is, the more we do these Facebook Live sessions and the wonderful feedback that we've been getting. So thank you so much for all the questions and the feedback that we've been getting on the Facebook Live sessions that we've been doing. But really that there is so much misinformation out there.
Absolutely.
And that's where the one thing that I can definitely say for sure is that you need to make sure that if you do have some kind of issue or question, that you get the right advice. And that's where I'm so grateful that you give us your time and share this information with us, because I know I read off your bio that sounds very impressive, but when you tell these stories about what you've experienced and it has been, you've got 40 years of experience, that's
right.
A lot of time to have learned all these nuances.
Yeah, and it's not. Look, I mean, I've done this my whole life. It's not really a money issue at this point in my life. But what I've tried to do for the last 20-something years is, when the internet came out, I jumped on. I started a web page back in 1995, and I put all the information that I gathered over these years out to the public. So, even without retaining me or even making a consultation with me, you can go to the website and get this advice. And I figure it's a win-win, even business-wise, because if 99% of the people, I'm sure all the other immigration lawyers are reading it, and I want them to be informed so they can give you the right advice. And I know a lot of immigrants from all over the world are reading it. But if 99% of the people who read it never become my clients, but a fraction of 1% do, it's a win-win. Yeah. I mean, we're just an 8-attorney law firm. We get maybe 500 to 1,000 new cases a year. If I got 10,000 cases, I would have to really expand the place. So, go on the website, subscribe to the newsletter, follow us on social media, and you'll get a lot of this advice, and you'll get it for free, and I'm happy to do so.
Yeah, and thank you for doing that.
Thank you.
So we really appreciate that. We've gone way over time on this topic. We still have a lot of questions about adjustment of status that I wanted to ask Carl, so probably we'll have to do that in the next Facebook Live session. We will be skipping next week. Unfortunately, I am traveling. I'm going to see some of our hospitals on the East Coast. So we will resume these Facebook Live sessions 2 weeks from today.
That's Tanya and I. Yeah. My office, we've already prepared a weekly schedule for August. So I'll take a little break, but my other lawyers will do that.
All right. Sounds good. So thank you so much for your time, Carl. Thank you to everybody who's been watching. We really appreciate, as I said, all the questions and all the input that we've been getting. I think that this is a valuable service that we're providing, and we are really happy to be able to do that. So have a great weekend, and see you in 2 weeks.
Bye-bye.
Thank you. Bye-bye.